welcome everyone. I think we are going to start. Just watching people come in. So, welcome to another of our fireside chats. This one is on the role of law. I'm really excited for this session. So, we are welcoming for this conversation Apolline Roger of Client Earth, Katharina Pistor, who is joining us online. There she is. Welcome, Katharina, of Columbia Law School, Sung-Hyui from Bates Wells, and Jess Hacket of the Coalition for Impact. Welcome, all of you. Before we dive into conversation, we have a question for all of you. So our question is, what comes to mind when you think about the relation between law and wealth? And this is on a poll, so on the Spot Me app, if you make sure you're in this session. If you're not, click on More and click on St. Pancras Room. And then there should be a button that says Poll. If you click on that, it's a word cloud. Write in any words that you can think of that come to mind when you think about the relation between law and wealth. We're going to give you a minute to do that. Tax loopholes, okay.
If you are not on your phone, that's a good sign. So we're harmony. Yeah.
Harmony is interesting.
Yeah.
Structures, self-preservation. Laws protect the wealthy, restrictions, more loopholes.
Reinforcing loops.
Tax justice.
It has always been.
As it has always been.
Status quo.
So maybe we're saying no more. Lovely, thank you. Thank you for sharing those. That gives our speakers some idea of where you're at. So, excuse me, 1 second. I'm going to ask a question and then leave you to kind of dive in for a bit. So my first question to you is, how has the law and lawyers contributed to extractive and accumulated wealth? Katharina, can we come to you first, please?
Yeah, of course. Hello, everyone, and I apologize for not being able to be with you in person. So let me just say a few words about the lawyers, whom I like to call the masters of the code of capital. So I'm essentially arguing that capital is not just a thing, but capital is a legal quality that has to be grafted onto assets to turn them into wealth-generating assets. And that already tells you something about the role of lawyers, because somebody has to graft, really like grafting a branch of a plum tree on an apple tree and you get a new fruit from that experiment. So somebody has to graft the legal toolkits, the legal modules of the code of capital onto certain types of assets to make them wealth-generating assets. So think about land. It's a piece of dirt. You can graze your cattle, you can harvest the fruit, but if you want to make money off the land, you need to be able to claim it as yours and be able to exchange it with others. That is, you must be able to transfer title. That's what the law does. If you want to agree with anybody about any kind of transaction, you can, of course, do this. If you want to be able to enforce that transaction in a court of law and thereby mobilize the powers of the state on your behalf, it has to be an enforceable contract. So what we have in the area of private law, which is the law that governs relations among non-state entities, and typically we're saying this is horizontal, although it not necessarily is, because it can be very hierarchical. But the idea is that non-state actors engage with one another in private transactions, and they can use different modules of the code of capital, different tools in the toolbox of private law, contract, property right, the law of business organizations, collateral law, etc., and then put those together in a way that gives some stronger rights over others. We're trying to solve disputes and conflicts peacefully, but that means we're basically pre-assigning stronger rights over weaker rights. We're allowing some to hide their assets behind veils so they can grow. We're limiting the type of actors who can have access to these assets, and so, again, they can grow. And of course, you can start trying to hide then your assets from also the tax authorities, not only from other private creditors, so that they can grow and you can claim them. And this is basically the work that lawyers have learned to do. They are designing the transactions that parties engage in, that their clients wish to have, and they're trying to give their own clients the strongest rights. And in this process, they're also pushing the limits of the law. But let me just maybe stop here and hear what the others have to say, and I'm happy to come back in and clarify anything that might not be entirely clear from what I've said.
I think what kind of Katharina has said has resonated so strongly, and as a practicing lawyer, so by way of introduction, as you've already said, Vicky, I am working in the purpose and impact team of a law firm called Bates Wells. But before I worked at Bates Wells, I was a banking lawyer, so maybe one of the most mastery of Code of Capital kind of lawyers that you can find at Clifford Chance for 10 years. And what was very interesting was that in terms of everything that you said, Katharina, it is entirely enforced even in the education of lawyers and what kind of firms they go into, because the big commercial international firms that enshrine that code of capital get paid the most. And so if you have young lawyers, then you are attracted to go into that profession, or maybe pressurized to do so by family, etc. So you go into that area kind of only being kind of, I guess, not blinded, but entranced by the glamour of it and the glitz and kind of what you intend to get paid. And when you are in that role, you very much are a tool and a utensil of the wealthy and the powerful. And the way that kind of law is practiced and the way that the laws are formulated are, as kind of Katharina said, to kind of solidify that status quo and solidify those relationships. So what we see in the practice of law now on a day-to-day basis, just to give a few more practical examples of how I have seen this manifest in practice, is that, for example, again, I guess taxation is a very big point which many of you have already flagged. I think the law very much protects and maintains the existence of safe havens in a number of jurisdictions and doesn't make them illegal, which definitely encourages the preservation and hoarding of both personal and kind of corporate wealth. And a lot of these, you know, as a matter of some sort of shame, are associated with kind of the British Empire of the past, so the kind of the Singapores, the Cayman Islands, the Bermuda, you know, Jersey, all those kind of places. So that's kind of one manifestation of it. And in my old job, we had like a tax team internationally of kind of 200 plus lawyers across the world to really solidify those relationships. What we are seeing in my kind of current job at Bates Wells, where we are trying to push law towards more a kind of a fairer system for people and planet, is that one thing that we are up against are traditional fiduciary duties of those who are investing or managing wealth. So this kind of again reinforces the notion of the law being used to preserve the status quo and to preserve the kind of hoarding and accumulation of wealth. So traditionally, investment managers and pension trustees are supposed to invest in a way that prioritizes financial returns and takes into account financial risk, but without consideration of social and or environmental consequences and or the social and or environmental interests of their clients. So even if you wanted to invest in a way that was perhaps kind of less to do with financial returns and more to do with people and planet, traditionally it has actually been very hard to do so. And investment managers and pension trustees have come to us and said, "Oh, you know, we're quite nervous about advising on this. This is beyond the remit." There's little bits of seeds of change, but there is definitely still kind of a current towards that. And in terms of kind of what Katharina was saying about the code of capital and how it manifests itself in the entities being invested in, so a lot of the companies, you have the law also manifesting itself through shareholder primacy being an overriding factor. So this is the notion that in order to meet directors' duties, the directors are able to consider social and or environmental harm, but shareholder primacy comes first. So if there's any kind of inconsistency in terms of what is in the interest of the shareholders, which is often, not always, but often profit maximization and or harm to people and planet, directors are liable to be sued and to be negligent if they don't prioritize what's in the interest of the shareholders. So there's lots of different manifestations of this that we see and that we are pushing, that I'm and my colleagues are now pushing against, but it's actually quite interesting. I was very blind to this at the start of my career. It was just told to me as this is just the way that law is and our goal is to look after our clients. But now that I'm kind of on the other side of the fence, as it were, you see these parameters and barriers everywhere, which can show kind of Katharina's points in action.
And I think building on the law firm culture, I mean, as a lawyer, so I used to be in private practice. I then went to a single family office and then a trust company. So very much on the private wealth side. I'm now at the Coalition for Impact, trying again to make change in the financial system. But most lawyers are charging their time in 6-minute units, and that drives the behaviour that success is the number of units that you record, the number of units that you bill. And so where's that time for reflection, to stop and think about what your role is in society? We didn't ever have that conversation around what's the role of tax. How do you have the conversations with your clients? What's your values? How do we build your values into it? There just isn't time for that. And there's also this drive to, we need to find a neat, tidy solution, that we as lawyers need to have the answer. You have come to us for the answer. And if we can't find it, somehow we're letting you get down. Again, not a lot of this was actually told to me explicitly the first day I walked into a law firm, but it was picked up from the behaviour of all my colleagues, and I felt to succeed that I had to replicate that behaviour. And it was over this time that I sort of had these questions rising in me. Well, how does this align with my values? How do I do this? And sort of having this struggle, and then how do I put it into practice and change? That was some of my experience.
Yeah, it was. I remember when I was at my old firm, and I did an international development course over the weekend, and I told one of the partners I worked with, and he was genuinely like, "Why would you do that? It doesn't make any sense." And I was helping my dad with some research that he was doing, because he did masters in philosophy and religion after he retired, and the partners were genuinely threatened by that, because these kinds of ways of thinking beyond what is in the interest of your commercial clients. They really wanted to do hobbies and holidays that took you to things that you could talk to your clients about over dinner. So all of even your extracurricular activities were funneled back into serving your kind of commercial clients rather than potentially challenging them.
I recognise that. I think, Katharina, do you want to jump back in, add anything to what you've heard?
So I think I agree with everything. There are lots of little things that I could just reinforce. So, for example, that the law creates certain privileges for wealth. So the companies were mentioned, and tax evasion was mentioned, and of course we secure this by having limited liability and a clear separation of different legal entities. And that even states that know, when the states know that companies are using this for tax shelters, they're still respecting the legal form that has been designed to hide these assets from tax authorities. So I think it's one thing to call out the tax havens, which were created by was sort of facilitated by the UK and other post-colonial countries. But it's another thing also to say that even today we still respect the legal forms that they use to hide these assets. On the issue of the lawyers and their training, I teach at Columbia Law School, so it's kind of also a schizophrenic situation to train the coders, because given the fees we charge in this country in particular, we're just hitting $80,000 per year times 3 times living in New York, which basically means that many of my students have no chance but to go into the big firms and code capital for long enough to pay back their debt, at which point they already have established a certain lifestyle and have internalized the norms of big law. I think it's changing to some extent. We'll come to this point later, I think, but it's changing because the younger generation also realizes that there are limits to what's going on and have ethical concerns. But I think there's a whole culture of lawyering that has been established that makes it difficult to break out, and I appreciate the work that you are doing already in trying to get us there.
And just maybe just one final point for me is that a lot of us in this space, the impact space now, are from big law, including myself. And what I have found is that a lot of us subconsciously bring across the norms that we learnt from our traditional legal practices. This notion of law being a battle of two equal sides, fighting out the terms, protecting your client, maximizing the wins, minimizing risks. And that can cause problems in the impact sphere because we are reinforcing some of the power imbalances and issues that may have been appropriate in a pure code of capital arena but are not appropriate in an impact arena. So I'll leave it there. I think we go on to that in the next bit.
So insightful and honest. This is great to have this conversation. Thank you. Also, let's be honest, a little bit depressing. So can we turn to, and Apolline, you may want to start this first. How can the law and lawyers contribute to stewarding wealth for people and planet? Where can we go?
Yeah, I mean, I guess you're starting to see the pattern, right? Because of course, like we share the shadow here. If you turn into the light, like what is the reverse and what can be done? But I am from Client Earth, which is an NGO composed mostly of lawyers who use the law to protect people and planet. So when I hear that question, I will answer from the point of view of the legal activist, someone who tried to use the law in every way we can to bring social change. And social change, you know what social change we are trying to achieve here. And I think here, when you approach the law like that, you go back to that first word cloud that you offered us. On one hand, the law as the tool for the powerful, and on the other hand, the law as a tool for the powerless, something which can protect. And so the first image which comes up is David and Goliath. You know, the small takes down the giant, and the arms of the master are used to take down the castle. It's a very hopeful image. I think that's a very powerful thing which comes with legal activism. Unfortunately, even though it's possible, it is also quite difficult in that sphere. And the reason is that you have quite an alignment between practice, worldview, power, and law. And when you have that alignment, it creates a watertight bubble, which is quite hard to break. But of course, like all of you here, you are piercing little holes. Like Katharina's great work is piercing little holes. Like what you're doing is piercing little holes. So you're starting to have some leaks, to have some cracks where the lights can come in. However, there is still some watertight effect here. So what can be done when you're a legal activist? And I'm NGO, but you can have legal activists everywhere, in family office and in big law firm and in-house, of course. The first thing that you can do is exposing the situation. And here again, Katharina wrote a great book called The Code of Capital that I encourage you to read. It's just, it's a rigorous exposure of how the law created that weird living organism, which is capital today. She used the term of graft at the beginning. It's kind of the first genetically modified organism here. Land cannot engender land, while capital can engender capital. It's actually a high fertility rate here. So yeah, exposing how it's done, how financial rules, like value generally, are given primacy, how shareholders are given primacy, how their capital holders are shielded from liability, how they can pick the forum, like the best law in the world, which is the most protective for them, how they can use their social and economic power to influence policy and legislation in their favor. All that needs to be exposed. And that can be exposed through great research and great stories and the work, of course, that you're doing through advocacy, through litigation. Litigation as a forum. Think about all the climate litigation which is happening today. The details, what's happening in the courtroom, what is written matters. But actually, even just the fact that it exists matter. I suspect that many of you don't know the details, but still know about climate litigation happening. You have seen it in the papers. You've seen the impact of that as a forum for society to reveal what's happening and to see where we are and where we want to go. So exposing the situation, then stopping the most harmful practices. And here, of course, we can think about the gigantic flow of money which still goes to fossil fuels, for example. You can also think about the narrow interpretation of directors' duties in companies, which is still holding the system in place. So here, for example, Client Earth brought a case before the UN Human Rights Council in 2021, where we challenged Saudi Aramco and its financial backers, so Citibank, HSBC, JP Morgan, Chase, saying that when you actually invest and develop upstream fossil fuel projects, you're actually in risk of violating human rights because of the climate impact of all that. And the human rights experts agreed with us. So here, what we used is that bridge. It was not a perfect alignment between practice, law, power, and worldview. Human rights was a sphere of misalignment that you can use to stop a practice or at least to expose it. Another example, as a shareholder, so Kleiners has shares in some companies that we use, as you can imagine, also for our cause. So we were shareholders to the energy company Enea in Poland. And there was a project to build a huge coal power plant there. And so we use our shareholder position to challenge a decision, saying that it should just not happen. And here what we used is the overlap between financial interest and environmental interest. The construction of that big coal power plant didn't make financial sense, it didn't make environmental sense. And that case was won. So that, of course, as you can imagine, I think I heard that theme a lot already in the conference. More and more there's a recognition that you have an overlap between financial interest and environmental interest. However, I invite you to be careful with that path as well. Even though it is very useful, it is a very important tool, the law has a hold on our hands, on what we do, on our head, on how we see things, how we understand things. It also has a hold on our soul, like how we see ourselves. And so the more you do that argument, the less you leave aside arguments which is more about the fact that nature matters by itself, that we could live in harmony. So you have to be careful with that. And then maybe I will be very short on that one. The last thing that you can do is to start creating the new, of course. Some changes which are needed can happen only with policy and legislation change. The end of the tax havens, that's the first thing you thought about. That can happen only then. So, and we don't have that right now, let's be clear. But you can prepare for it because there might be a change of government. We have a lot of elections this year. Some of them have not gone our way, unfortunately. But we also know that there are shocks coming. We already heard the impact on the insurance industry, and we know the insurance industry is crucial for the financial system. So what will happen when we have those first shocks? And here, being prepared to play something matters. And then for some changes, you don't need to wait for policy. You don't need to wait for legislation. Everything that Katharina described, those models of the law which are like clay, which are designed for lawyers to mold and to use and to adapt to the needs, what they're already doing in Betswell. Well, all of that can already be used to create the new, to create another relationship to nature, another relationship to time, so think those 7 generations that we were invited to think about this morning, like another relationship to other, being more in partnership rather than competition, and another perception of value as well. So we can already start using all those modules to create the new, if we find the right allies and the people who want to use them, of course.
I'm going to just jump in really quickly and let you kind of carry on chatting, but just as a reminder, if anybody's got questions, please add your questions on the app and we'll hopefully come to them in a little while, but you carry on that thread.
No, that's really kind of insightful, Apolline. And as you were speaking, I was thinking maybe if we were to think about what role law could have, we need to be clear in our minds as to what the law should be. So what is that overall framework and philosophy that we are trying to achieve? Because if we don't have that agreed in some form, then we can all kind of spiral off into different directions or at cross purposes. So I don't have the answer to that as such, and maybe Katharina has already thought that through and may have some thoughts on that, but there's something about financial returns and the accumulation of wealth not being carried out at the expense of so much harm to others, to people and planet. So then the question is, what should those 3 elements, what kind of priority should those 3 elements have amongst each other in terms of human rights? There's something there about the equality of human rights and preserving and protecting that rather than allowing that hierarchy of certain individuals to rank above others based on power and wealth. There's something there about the kind of innate value of nature, as you were saying, Apolline, and I know that kind of Kate Raworth and others have talked about donut economics and being mindful from a sustainability perspective of pushing the environmental ecosystem until it breaks. So we need to operate within the donut of what the resources are available to us, but there's something there about the inherent value of nature and climate there. And then there is wealth. I think there's quite interesting sessions today about not demonizing those with wealth automatically, and we all need to survive and have a sufficient level of comfort and financial stability, but how much is enough, I suppose, rather than trying to maximize it at all costs. So I think those wider questions perhaps need to be debated and agreed to at least come to a framework of what we want the law to look like before we then take specific steps to implement some of that. So we'd welcome thoughts and questions and observations from you all shortly. And then in terms of the specific manifestations of some of that, what we are starting to see at Bates Wells and amongst our peers, including you, are attempts to make the law work more in that towards that direction. So, for example, getting back to my previous point on Companies Act and how it allows directors to prioritise shareholders and wealth and their kind of financial returns above all else. We're trying to push something with BLAB UK called the Better Business Act, where we are changing company law through just a very few tactile changes in the draftings rather than lots of complicated legal words, saying that directors have to prioritise social and environmental impact equally alongside shareholders' interests rather than shareholders ranking above. And that will obviously be complicated in terms of how you work that out in practice, but it's a very simple change to the wording that could have lots of very interesting manifestations. Directors can then, choose a contractor or a supplier where it could be a bit more expensive for the company, but could, protect human rights or have less environmental damage without the fear of being sued by powerful, wealthy shareholders is kind of one manifestation of that. And I think what you were saying, Jess, about the culture of lawyers and law firms, I think for those who are lawyers in the room, we need to be kind of aware and own and be responsible for the role that we may inadvertently play in making the situation worse. So, at Bates Wells, we're co-leading a project called with Equality Impact Investing project called the Equalising Deal Terms project that looks at some of the power imbalances that even impact investments and philanthropy can have between funders and those who are funded. And we as lawyers, and I touched on this very briefly before, we bring our traditional investment training to write complicated documents. They're very long. They are very much on the side of the funder a lot of the time. They enable the funder to dictate what the recipient of funding can do. We're the ones who, the funders are saying, we want you to include this in your theory of change. We want you to give us loads of reporting. You can't do this, that, and the other without a consent. So in doing that, are we as funders and lawyers perpetuating some of these inequalities that we are here to try to supposedly combat and counter? So I think a lot of it is inadvertent. I'm not pointing fingers at anyone. I am definitely accepting blame for my part played in having that kind of commercial legal training. But it's just being mindful of, as well-intentioned as we may be, also being mindful of how we could perhaps do better in our own day-to-day practices.
I recognise that in sort of redesigning term sheets. I was part of a project looking to design a regenerative term sheet, and it's so once you start digging in, you realise how much of it you sort of have to undo of the old system. So whether it's valuation, whether it's attitudes to risk, and as a lawyer, it starts to feel you can start almost seeing where it could go wrong in a court with a client. It really is just built into you to protect your client
and yourself.
Yeah. And going through that process of how does this really show up? How can we really be doing this differently? And I think building on your point about a framework as to what law should look like, but actually how as lawyers do we talk with our clients? I come particularly from the private wealth side around their values and I will sort of reference Good Ancestor movement. I can see some of the team here in the progressive advisor movement. That was the first place that we started saying, what is your attitude to tax to clients, not just assuming that everyone wants to minimise, and then being able to build that in. I think it was probably about 7 years ago now that I had the first client that said, I want to pay more tax. And my attitude was, why? I wasn't prepared to be able to help my client, and I was somebody saying that I can see the system is wrong. So actually being able to talk to clients about values, and then the tools that we already have, looking at them so that they are set up to be able to build in those values. I think, yes, we've still got to connect it back to society. It can't just be sort of individuals, but I think there is that space. But perhaps if I hand over to Katharina.
Yeah, I think as you could hear already, I think we have to both play offense and defense at the same time. Offense is basically pushing back, rolling back I think excessive ways in which we have coded this capitalist system. And when you really think clearly, it just does not make sense, right? It does not make sense that we extract surplus no matter what from corporations or whatever happens with the company later on. I've written several times now about the Boeing Corporation, which is a classic example for what happens if you have basically a committee of the board of directors that looks for financial risks, but no committee that looks for risk associated with the safety of airplanes. And luckily, even the Delaware courts have pushed back now and said, if you're flying airplanes, if you're producing airplanes, a critical mission is that these airplanes shall fly. And it's at that basic norms. Yeah, I know it's funny, but it's also tragic because it's at that basic level where we have to start saying the system that we've created just makes no sense. So just also, I think it's a mindset clarifying where we're just thinking wrongly. It's sort of using the tools that we have in pushing back, bringing climate change actions, etc. And then I think really important and the hardest part for all of us is reimagining how else it could be. One of the things that I'm thinking through a lot is why it is that we have two legal systems, really, most of us. We have a private law system that is based on this idea of individual freedom and the ability to contact with everybody, that just consent given in whatever flimsy form is enough to impose my will on others. And on the other hand, we have a constitutional democratic system where we're saying, actually, we're bound by reciprocal norms, we're trying to have checks and balances, we're holding power to account. We're not holding private power to account. And so I think just trying to unify that and say we actually have to hold all power to account in one way or another, not only corporations to the shareholders, but to the people who are affected by them, and to push for a normative agenda and then think about how to realize that within existing legal systems, but also by maybe making some base strategic change. And I agree that it has to be simple and well placed and strategic to make a dent. But I think on a slightly more abstract level, I'm saying exactly the same that has been said before, and I'm in full agreement.
I'm just looking at the time, we've got some questions coming in. So if that's all right, I'd like to ask you some of those. So first question we've had in is, with regards to fiduciary duties, does the current law enable investors to mobilise capital that benefits people on the planet already, or do we need to change the law? I guess that might be a to what extent, how far are we question.
Maybe if I kick that off. So we are seeing gradual movement on that, but not enough. So one area where it's glaringly missing is in terms of pension fund trustees, and pension funds hold enormous amounts of money. I remember being a young lawyer and just being really bored at the thought of being a pension lawyer. But I think now that I'm aware of just the scale of monies involved, and obviously there's a tension here because you want to keep the money safe and generating a good enough return to fund people's pensions when they retire. So there is that. But so far there has been a real unwillingness to change the law, and a nervousness by pension trustees to even take into account the wishes of pension beneficiaries, to take into account social and environmental interests, in addition to financial ones. So that is quite a long way off. There are areas where it is getting better. So in the context of charity law, we recently won a case called Butler Sloss, which some of you may be aware of, where we went to the court to get their confirmation that if you are, for example, an environmental charity and you have environmental charitable purposes, then you are empowered as a board of trustees to make financial investments in things that might have a slightly lower financial return, because you're not investing in things like fossil fuel companies that might have higher financial returns but go against your objects. And it's kind of almost startling and doesn't make any sense, to go to Katharina's point, that we needed that case to clarify it. But for a very long time, trustees were very nervous that they were being pressurized by other members of the charity to maximize returns to help the charity and to help beneficiaries, even though what they were investing in was kind of cancelling out their positive impact. So we're having kind of positive developments like that, which say that in terms of the legal duties of charity trustees, you are able to take into account kind of social and or environmental, as long as it relates to your charitable purposes, alongside financial returns. But I think in terms of investment managers, there are increasing kind of regulations kind of around that, and I think that Europe is doing quite well compared to, for example, America, where I think there's a huge backlash against ESG, and certain kind of Republican states are actually banning and passing legislation to ban the consideration of kind of ESG factors into investment strategies. So the dial is moving multiple ways. So there is some progress, but still a long way to go.
Does anybody else want to add to that, or shall I move to the next question? I'm going to move to the next question. Thank you. And thanks to Stephanie Dalwood for that question. So Astrid Schultz has asked a question. The panel discussion is at the higher level of the law. Can you also comment about how specifically we can equip individual lawyers to advise clients on how to better align their portfolios, investment decisions, deal structures, etc., with their values? It's often lawyers that drive discussions inside organisations back to the most risk-adverse conservative stance. So how do you do that, and how and where can we find the brave lawyers?
I mean, I think the brave lawyers are out there. I think it's empowering them, giving them that space to be able to have these conversations, but also the tools, because suddenly you're into this like grayer area of values and what's your objective. It takes it away from like the law is a written is something much more concrete, which I think most lawyers probably enjoy playing in the grey area, but there's boundaries, whereas when you come into individuals, so I think it's starting as early as law school. It's talking about these topics, it's talking about values, it's talking about the role of lawyers in society, and then it's bringing them into law firms. I don't know if you want to talk about perhaps a bit more Bates Wells and sort of your model and some of the differences you have to other law firms.
Yeah, sure. So one thing that Bates Wells really encourages all of its lawyers to do, which I have personally also felt very empowered by, is not to just advise on the law, but to help change it. So a lot of the kind of worry about whether or not they can advise clients in a certain way that takes into account wider impact is you see the piece of legislation and then you're just like, oh, that's what the law is, so that's what I have to abide by. But I think it's not just Bates Wells, there's a big community of lawyers who are thinking in this way. So some of you may have heard of GALE, the Global Alliance of Impact Lawyers. So this is a really international community. So if you're not part of that, would very much encourage you to join and be part of these discussions, and to look at what should the law look like, what does the current shape of the law take, and how can we make changes and support each other and have a forum for discussion and debate and moral support in order to be able to make these changes. So maybe if you become part of the discussion about where the law is and how it could be better, then it then empowers you to be able to advise more comfortably on being more creative with the law. And that is, I think, on the law school point that you just made, and just to kind of maybe share with Katharina as well, is that as lawyers, especially at law school and also in practice, we are instructed very late in the day without any background knowledge a lot of the time as to what the underlying relationships, dynamics, risks are, and then we're just told to document things. So as lawyers, for those lawyers in the room, I would encourage you to explore these wider dynamics, because that can help to shape your advice. And as clients of lawyers, if your lawyers come back with a very conservative answer, please do challenge them nicely, but because that they would. I mean, I think a lot of us as lawyers entered into the law because we wanted to help with justice in some way originally, and then things like debt from law school and stuff and other things have pushed us into various directions. But please don't be scared of having these more holistic conversations with your lawyers, because that may help to untangle and unleash some creativity.
Maybe one last thing on that. I think in a lot of our discussion, we had the dichotomy for lawyers as master, master of the code, or servant. You're here for your client. I think in both those roles, I guess, or positioning, the lawyer has a knowledge which is almost like intellectual property. You have it, you keep it, you give it to your client. So I think a very big important thing that all the impact lawyers can do, and Gail is doing a lot of that, is to externalize, actually to give away your power by sharing the knowledge and making it as simple as possible so non-lawyers can access to it too.
Yeah, maybe I can just add a word about education. So I think we also have to open the minds of our young lawyers. They come really to law school and they want to change the world. What we see very often is after their first internship in a big law firm, they come back jaded. They understood that this is not what their job is all about. But I think we can counter this also through the kind of debates on norms and values that you mentioned, but also showing the different techniques. So I've just started teaching a course on the non-capitalist enterprise, like for profits, but that don't put profits over and above everything else. And it's not that easy to think through the mechanisms, and one always sort of falls back into the trap of comparing it with the corporation, the classic business corporation. But it also opens the minds, and I had my students write basically a charter for non-capitalist enterprise as an exam, and it was just a lot of fun to see what they can come up with. So just as the coders of capital have been able to push also the limits of the law, so law is both conservative, but also there's a lot of pushing there for trying to move the boundaries of the existing laws. And I think advocates for a different type of law can do the same in reverse. And just to use a quote from Joanna Kuziak, who wrote this wonderful book on Radically Legal, she talks about trespassing on the law. So I think we can trespass on existing law and push it into a slightly different direction as well.
Thank you, Katharina. So we're a few minutes before we all get to take a break for lunch. So I'd like to ask, apologies to Stuart and Matt, whose questions I haven't been able to ask. I'd like to ask a final question to close with, which is, what brings you hope that we can collectively steward well for people and planet? And perhaps we'll come to you, Katharina, first.
So I think what gives me hope is to watch lawyers, especially practicing lawyers with a lot of experience, see switching side and trying something different and being very creative about their work. And what gives me hope also is the next generation, where I see many more students actually asking probing questions and looking for different types of answers. And I think, and this is happening, just in so many different little walks of life. And I think that's really important, that this is not siloed, but it's kind of a movement that might still look small. But I believe when you think about history, that big things happen when a lot of small things happen and push somehow in a similar direction. So that all together gives me hope.
I think it's similar for me. It's the fact we're in a room talking about this that I'm finding more and more lawyers that are changing how they're working, who they're working with, what they're doing. And I believe that will grow, and it will show other lawyers it's possible, because I think most lawyers are risk averse themselves. And so seeing these examples will hopefully inspire others.
I think for me, a very practical event has given me hope is that as part of the Equalising Deal Terms project, we had a legal roundtable hosted by the Growth Impact Fund, which some of you may know as a UK social investment fund focusing on funding underrepresented founders. And they get a lot of pro bono legal support from a lot of the big city firms. And they were saying to us, they're doing these really aggressive negotiations, it's taking ages, like all of these things that we've talked about are being applied, and the founders are very upset. So they wanted to use the kind of principles that came out of the research project to maybe overhaul their legal processes. And we got their pro bono lawyers in a room and to talk about how we could advise differently. And I was very nervous, because I thought there'd be a lot of pushback. They were like partners who've been doing this stuff for like 30 years. I thought they'd be really set in their ways. And what I found so inspiring was if you give lawyers the safe space to think differently, to ask any question, including the stupid questions. We had investors and investees in the room so they could say, you know, why are you comfortable with this being deleted? And how does that work if we don't have that? All of them got really into reimagining what the law could look like. So I think there's real hope there that we are not beyond salvation. And if you provide these forums and these spaces and allow those working in this space to think differently and to do it in a kind of very open, receptive way rather than like a judgmental, blamey kind of way, then I saw some very promising seeds and sprouts of how law could be done differently.
On my side, like who talks, like who asks for change matter. I remember a meeting a few years back. I was with policymakers. We were talking about toxic pollution and how to end it in Europe. And I had some colleagues, NGOs, amazing lady. She had been working in the space for 20 years. She's a toxicologist. Like she knows her stuff. So we talk. She makes a point. I take the stage. I make a point. She talks again. The policymaker stops her, saying, "No, stop it! Like I want to hear the lawyer." I was making exactly the same point, exactly the same. But the lawyer was objective and could be listened to and trusted. So if you are a lawyer, your voice matters, like your positioning matters. If you're a capital holder or a capital manager, maybe even more, to be honest. So using the social capital really matters. And so what gives me hope is to see, again, the shift in those spaces. And I don't know if you know the work of Damon Santola on social tipping point, but his research showed that you might not need the 51% or 60% that we think about. You might need 25% of change in a group to shift a social convention. And that's great. Like looking at that room and how many people are here today, I feel that maybe we are quite close to 25%. So stay here and bring other people.
Amazing, thank you. And apologies again, I think there were more questions I wasn't seeing as well. Judy, Rosamund, others. So please use the platform, keep chatting, and thank you to all of the speakers, and especially Katharina for joining us from afar as well. It's now lunchtime, have a break, and the next session starts at 2:10, but let's thank you.